Good morning, ma'am. You are Evelyn Odom. And Miss Odom was previously here on cause number 26 DCCR 0403, entered a plea of guilty to a lesser offense of Class A misdemeanor evading arrest or detention. And I reset it for sentencing. Miss Odom, have you been arrested for anything between when you were here to plea and today?
Yeah, me.
All right, then any reason not to go forward?
No, Your Honor.
All right, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of the Class A misdemeanor of evading arrest or detention. Sentence you in accordance with your agreement to a term of 30 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody previously on this case that the law gives you the right to receive. I'm handing you the trial court certification that shows that this was an agreement that I followed, so you have waived your right to appeal. All right, good luck to you, ma'am. You can go back with the bailiff. Good morning. Are you Michael Sarant?
Yes, Your Honor.
And Mr. Sarant was previously in court, entered a plea of guilty in cause number 25 DCCR 1691 to the third-degree felony offense of evading arrest or detention with the use of a vehicle. I've received that pre-sentence report. Has everyone had an opportunity to review that report?
I have, Your Honor. Yes, Your Honor, we have.
Any additions or corrections?
None from defense. None from the state, Your Honor.
All right, Mr. Sarant, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, however, you will follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 3 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. There is a recommendation for some spinal tap treatment. I didn't really see a lot of issues with that. So what I'm going to do is just order an assessment first, and we'll have a mental health assessment done. If there's some issues that need to be addressed, then whatever that is, if there's any, you'll be required to follow whatever treatment recommendations. You understand?
Yes, ma'am.
All right. If you do everything you're supposed to when you're on this probation and follow all of the rules successfully, then at the end, this is the case will be dismissed. It's a great opportunity. You don't have a felony conviction on your record. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and you could be sent to prison for between 2 years and up to 10 years. Do you understand?
Yes, ma'am.
All right, I'm handing you the trial court certification that shows that this was an agreement that I followed, so you have waived your right to appeal. You just need to have a seat here in the courtroom. Probation is going to call you up to her desk when she's ready to go over your paperwork, so just listen for her to call your name.
Yes.
All right, good luck to you, sir.
Thank you.
Good morning, sir. Are you Marvin Davis?
Yes, ma'am.
And this is cause number 26 DCCR 0754. Mr. Davis is charged with injury to a child, elderly, or disabled individual. What is the announcement?
Judge, we've gotten an offer from the state that I do need to go over with my client some more. Also, he's involved right now with his parenting plan and everything going on with CPS. So part of that is that we're trying to let him get a little further down for us to complete some of those classes
Sure.
before we proceed. So we're asking just for one reset.
All right. Any issues? that you-
No issue that I see, Your Honor.
All right, I'm going to reset your case, just a normal reset. It's about 30 days. Make sure you follow through with everything on that safety plan. That's only going to help you in this case as well. All right. Stay in touch with Mr. Lewis. He'll let you know when your next court date is. All right. You're free to go.
Good morning, Your Honor.
Good morning. You're Lance Charbino.
Yes, ma'am.
And this is 25 DCCR 0096. Mr. Charbino is charged with credit card or debit card abuse. And what is the announcement?
Judge, we're asking if we can set this for a plea for next week. He will be able to have that restitution by tomorrow, should be, so we be able to have that paid before we come back.
Okay. Any issues, Mr. Nichols?
That's fine, we stand.
All right, we'll reset it 1 week for a plea. So it'll need to be taken care of next Monday. All right,
Thank you, Judge.
She's my,
Good morning, Ms. Cantu. Would you please raise your right hand? Do you swear or affirm that you will truthfully and accurately translate from English to Spanish and Spanish to English?
Yes.
Thank you, ma'am. And sir, are you Guadalupe Reyes?
Yes.
And Mr. Reyes, in cause number 25 DCCR 1422, you're charged with a first-degree felony offense of aggravated robbery from May 25th of 2025. And what that means, sir, is that if you go to trial and you're found guilty,
Lo que quiere decir eso es que si usted no es culpable y vayan culpables,
the range of punishment would be a minimum 5 years
el mínimo va a ser de 5 años
up to 99 years or life in prison.
hasta 99 años de por vida en la penitencia.
Do you understand?
¿Usted entiende? Yes.
I have here on the tablet a plea bargain rejection that has your signature on it.
Ella tiene ahí en el tablete una ofrenda que usted la rechazó.
Before you sign this, did you go over it with Mr. Wasserstein?
De que usted firmó eso, usted lo discutió con su abogado. Yes.
Do you fully understand it?
¿Usted lo entiende completamente?
Sí.
Yes.
It shows that if you wanted to enter a plea of guilty,
Eso quiere decir que usted queda culpable, que declarara culpable,
that the state is offering a cap of 15 years in prison,
que le darán el tope de 15 años en la penitencia.
which means you would leave your punishment up to me,
Quiere decir que eso dejaría a usted que ella decidiera su castigo,
but I couldn't give you more than 15 years.
pero que no le podía dar más de 15 años.
I could give you 15 or less.
Podría dar yo 15 años o menos.
It would depend on the evidence that was shown to me at a sentencing hearing later.
Eso dependería la evidencia que le ofrecieran a ella durante el tiempo que va.
You have every right to reject that offer
Usted tiene todo el derecho de no aceptar esa oferta
and have your case set for trial.
y tener una juicio.
I just want to make sure you understand
Dios no es capaz de
what the possible consequences are if you go to trial
cuáles son las consecuencias si usted lleva este caso a juicio
and what your options are if you wanted to plead guilty.
y lo que son sus opciones si usted se quería declarar culpable.
And do you understand all of that?
Y usted entiende todo eso, sí. Yes.
And do you want to reject that offer and have your case set for trial?
Entonces usted no quiere refusar esa oferta y poner su caso para el juicio.
Sí.
Yes.
All right, then we will move your case to the trial docket
Entonces van a mover su caso para el juicio
and Mr. Wasserstein will begin preparation.
y se va a poner preparación.
Stay in touch with him. He'll let you know when you need to be back and ready for trial.
Tiene que contacto con el abogado y dejar saber cuando usted quiera esa persona.
Right?
Okay.
Thank you.
For the opportunity.
Thank you. You're free to go. All right, Mr. Hassan, you tested positive for THC. So obviously that is a violation of your bond condition. Well, what do you do that would make you test positive?
Ladies, Saturday and Sunday.
What?
Together, like family gatherings and stuff. That's it. No smoke. I don't drink, I don't smoke.
Well, you tested positive for a reason, and just being around it a little bit a week or two ago isn't going to make you test positive.
Oh, yesterday, Saturday and Sunday.
So why, if you know you're coming to court, would you be at some family gathering where everybody's smoking dope? What sense does that make?
I wasn't thinking too much of it, like in that.
So here's what I'm going to do because of that, Mr. Hassan. I'm going to require that you wear a drug patch. All right. And so you have 24 hours to get a drug patch put on. And you have to get it changed every 2 weeks. You have to make sure it stays on. There's no, it fell off or it's not testable or anything like that. If it continues to test, it's going to show me the amount in your system, not just a positive or negative. So that amount should be going down every 2 weeks. I get those every 2 weeks and I'll look at every single one of them. If it's not going down, then I'm going to assume that you're either around people you shouldn't be around or you're smoking yourself. Either way it goes, I don't care. It's going to show positive. So if you cannot be around anybody else, if you think that that's what's making you test positive, then I would stay as far away from it as possible because you're the one that's going to end up in jail if it tests positive again. Do you understand? So again, 24 hours, you need to get proof of that to your bondsman. They can also tell you where you can get it. So call your bondsman. They'll let you know where you can get. There's several different places you can go get that drug patch. You have to have it by noon tomorrow. Also, you need to have an attorney before that next court date. And if you don't, you need to bring me the names of 3 new people that you have talked to. If you don't do all of that, then those are all court orders that you will have violated. And your bond's going to be raised in each of your cases and you're going to go back to jail. Any questions? All right, step in front of the clerk. Good morning. Are you Tiona Hughes? And will your client waive the formal reading of the indictment?
Well, yeah.
Ms. Hughes, in cause number 25, BCCR 1058, you're charged with the state jail felony offense of debit or credit card abuse from May 19th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Burbank?
Yes, sir.
Do you fully understand
Yes,
this?
ma'am.
And, oop. Oh, now I've done it. Everything just went. How did this make that go off? Sorry. Do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for how long?
3.
3's the agreement? Don't write that in, or it didn't show up. All right, so a 3-year deferred probation. There would be a $500 fine, and you would be required to pay any restitution that would be determined between now and when we come back for sentencing. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection, state's fine.
It's admitted. Is there any evidence that Ms. Hughes is not competent? All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, but I'm going to reset your case for sentencing so we can get a pre-sentence report done. That'll give me more information about you, your case, and then we'll also get that restitution figured out between now and when we come back for sentencing as well. On your way out of the courtroom today, you need to stop and talk to probation. She's at that desk right over there, and she'll get that process started.
Okay.
All right, is there a way possibly the court would consider waiving the BSI and having to determine if there's a problem?
I have to order the restitution. If y'all knew the restitution amount, I could, but not without knowing it. Yeah. All right. We'll see you at sentencing. Ms. Robertson, in cause number 25, DCCR 1526, you're charged with the state jail felony offense of forgery of a governmental instrument from June 4th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Burbank?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 5-year deferred probation. Does not look like there's a fine, but there would be restitution that would be determined between now and sentencing. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection, state's fine.
It's admitted. Is there any evidence that Ms. Robertson's not competent?
No,
Right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case. Also give them time to figure out the restitution amount, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right over there. Okay, we'll see you back at sentencing. Good morning, you're Deanna Paul,
Yes, ma'am.
and this is 25 DCCR 1792. Ms. Paul's charged with stalking, and what is the announcement?
Your Honor, I visited with the prosecutor. There's been some additional evidence that's come forward that may impact the case. It will be, it's not going to be a trial shoot, but it could impact the outcome of the case. I've spoken with the state, and we're in agreement. He says he's in agreement with your approval. We just need one more setting.
Okay. All right, no issues. All right, this will be the final reset. So Ms. Paul, make sure that you stay in touch with Mr. Samuel, go over everything, anything that's new. If there's something you need to get to Mr. Smith, do that quickly, and we'll get a plea at that next court date.
Will do, Your Honor.
Okay, thank you. You're free to go.
Do I have to see anything before I get you?
All right, sir, you're Henry Littlefield. Answer
Yes,
out loud,
ma'am.
please. Thank you. And this is 26 DCCR 0395. Mr. Littlefield's charged with driving while intoxicated, third or more, and this is Ms. Malfino's. Any notes or anything that would help?
Judge, I didn't see anything that would answer its question today. So and I don't see any problems for a reason not to reset if it's okay with the court.
All right, I'm gonna reset it one more time. I know she's on vacation this week, but make sure you call, get
Yeah,
it,
sure,
see her as quickly as possible. And Mr. Littlefield, you have the auto ignition interlock device on your vehicle?
No, no,
Are you driving?
no, no.
Okay, so as a condition of your bond, I want to make sure that we're on the same page. You either do not drive or you have to have an auto
Yes.
ignition interlock device.
Uh,
Okay, all right, anything else then?
Nothing I'm aware of. Your Honor.
All right, we'll see you back the next court date.
Thank you,
Thank
Judge.
you.
I was informed. Good morning.
Good morning, ma'am. You're Kristen Bell.
Yes, ma'am.
And this is 25 DCCR 1812. Ms. Bell's charged with injury to a child, elderly, or disabled individual.
Yes,
What's your
Your Honor.
announce?
Your Honor, I spoke with Ms. French. There may be a change in the offer, due to some additional information, that she has been given, that I'll need time to discuss Ms. Bell, if possible.
All right, any issue with the reset then?
No,
Ms.
Your
Bennett?
Honor.
So Ms. Bell, I'm going to reset your case about 30 days. Make sure you call and make an appointment. Go visit with Ms. Holmes before that next court date. And we'll see if we can get an announcement. All right, you're free to go.
Judge, Ms. Bell has a warrant.
Oh, I'm sorry. Okay.
Right here for a second.
It's my understanding she has, a municipal court traffic ticket warrant. Is it possible that she can go
I
take
can't.
care of it?
No, I can't give her permission. If there's a warrant, we have a requirement or they have a duty to take her in.
Okay,
Yeah, there's nothing I can do with regard to that warrant. It's not mine.
okay.
All right.
It'll be a while before she's transported if you want to try to.
Yeah, it's
If
Beaumont
somebody-
Municipal Court.
If somebody can take care of it while she's still here.
I don't have nobody else supposed to be on it.
Do you know how much the ticket is?
It wasn't normal, I think, when it went.
Y'all go, take care of that back there, please.
Okay.
Good morning. Are you Francisco Garcia?
Yes.
And Mr. Garcia was previously in court, entered pleas of guilty in cause numbers 25 DCCR 0900 and 0901. I've received the pre-sentence report. Have you both had an opportunity to review the report?
Yes, Your Honor.
Yes, Your Honor, I have.
Any additions or corrections?
Not from the defense, Your Honor, we are asking that, the court, grant the 5-year deferred probation.
All right, Mr. Garcia, I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily. In cause number 25 DCCR 0900, find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made and defer all proceedings and place you on probation for 5 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. In cause number 25 DCCR 0901, also find sufficient evidence to find you guilty, but I'm going to follow the agreement in there as well. And defer all proceedings and place you on probation for 5 years. You're ordered to pay the $500 fine and to also follow all of the rules and conditions of probation. Part of that is going to be that you at least start off on the high medium caseload, which means you're just going to have to go a little more often, get on the right track. You will have no contact at all or communication in any way with Melissa Escalera or Jose Bravo Landa. That means obviously in person, but it's through any other means, electronic, Snapchat, DMs, text messages, whatever. Okay. You can't go where they live, where they work, nothing. Also, you are ordered to delete and destroy any images that you have on your phone of her, and that you will also be required to allow probation to go through your phone and look through all of that to make sure that that has happened. You understand? If you do everything you're supposed to on this probation, these are probations. These are excellent opportunities because you do not have felony convictions on your record. And if you successfully complete the probations, the cases will be dismissed at the end and you'll never have a felony conviction. The other side to that, though, is if you violate any condition of your probation, you can be brought back into court, found guilty in each offense. And in the burglary of a habitation, you could be sentenced between 2 years and up to 20 years in prison. And in the publishing or threatening to publish intimate visual material, you could be sentenced between 6 months and up to 2 years in a state jail prison. Do you understand?
Yes.
I'm handing you the trial court certification in each of your cases that shows that these were agreements that I followed, so you have waived your right to appeal. If you'll just have a seat here in the courtroom, probation will call you up to her desk when she's ready to go for your paperwork. All right, good luck to you, sir. Good morning, sir. Are you Michael Morgan?
Yeah.
And Mr. Morgan is charged with theft of property with previous convictions and cause number 24 DCCR 0590. And what is the announcement?
Your Honor, I've been having trouble with the discovery, and Mr. Smith looked as well as the videos. It's alleged theft from Walmart, and the videos were not working for me. Mr. Smith tried to, they're not working for him, and Mr. Morgan would like to see what's on video. So that's the hiccup we've run into. So we're trying to get with Miss Mayfield upstairs to see if they can figure out a way to get these videos working. And also Mr. Morgan was in the hospital yesterday from a apparent mild heart attack, possibly. This is records that the hospital gave. And he probably needs to go back. He released himself out because he knew he needs to come to court. He didn't want to have a warrant. So
Okay.
that's the other issue, but the biggest one is
So
I don't know.
well, I guess I'm looking back. It looks like it was pending and then he wasn't actually arrested on it for
Oh,
2 years. The warrant was issued back in 2024. And then it looks like it got returned in February 2026. Okay. All right, let's just do a normal reset. And that'll be about 30 days to give y'all some time to see if you can get that working, if it exists. If it doesn't, then we'll just need to go forward with what you got.
yes,
But
yes.
we'll hold it for that. I mean, I'll reset it for that.
Okay.
Stay in touch with Ms. Holmes. She'll let you know when you need to be back, sir. All right, you're free to go.
Thanks.
And then you've got Erin Riley. All right, good morning, ma'am. Are you Erin Riley?
Yes, ma'am.
And this is 25 DCCR 1192. And Ms. Riley's charged with assault of hospital personnel. And what is the announcement?
Your Honor, the same, we provided some medical records to the prosecution. There's also some jail records that her other attorney, because she has a pending misdemeanor, Ms. Cawthon is trying to get. We think that will help to mitigate with this case. This was a mental health episode. That's the reason why she was at the hospital and was charged with the assault. So we think if we can get that additional information to them, that might help with mitigating with the case.
Any issues? All right, I'll do a normal reset. I'll do your best to get all that
Yes,
before
ma'am.
that next court date. I'd like to get an announcement on
Yes,
the
ma'am.
next court date. Stay in touch with Ms. Holmes. She'll let you know when you need to be back. Okay, thank you. You're free to go. All right, so this is cause numbers 25 DCCR 1368, 1740, and then 26 DCCR 0720. Mr. Simon tested negative, which is obviously good, but Mr. Simon, you have to keep the drug patch on.
The day I lost it, I fell out of the tree, got wounded, and as soon as I got off, I went up there that day and then put back on. I wonder if there's a lady before that, the end of it was coming off. The thing they have put on top of it, ancient. I do tree work. And I mean.
Wrap it with something else
That's right.
yourself. I mean, figure it out. You're old enough to figure out how to keep a drug patch
I'm
on your arm.
now to make sure it doesn't.
All right, so I'm gonna reset the case to an announcement. Make sure you have it on, you keep it on. If I get another notation that it's not on, then it's gonna be probably a warrant instead of a hearing. Okay?
Okay.
All right, we'll see you back at the next court date.
Thanks.
Ms. Williams, so did you take the test? The drug test?
I said, so let's say 24 minutes since Miss John. I
What do
have
you take?
one-
24
I
medicines?
have neuropathy, I have vertigo, I have 3 prisoners on each side of my spine. I take hydrocodone, I take comfort for anxiety. My blood pressure was 230 over 134 3 days ago.
How did you get here today?
My ex-husband brought me.
So are you driving?
No, ma'am.
Do you ever drive?
No, ma'am.
So-
The doctor don't want me to drive. He took my license and put me back at Class B because I could have an aneurysm while driving.
All right, so here's the thing, Ms. Williams, I'm going to order also as a condition of your bonds in each of your cases, which is 26 0218 and 251430, that a condition of your bond, you are not allowed to drive ever any vehicle. Do you understand?
Yes, ma'am.
All right, and so
I can bring in a letter.
that's okay. And so we'll move these then. You want to, I've already done the rejection.
Rejection.
There. Oh, there it is. All right, so Ms. Williams, Mr. Parker has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and I can appoint another attorney today who could begin preparation for trial a little quicker in your cases. Is that okay with you?
Yes, ma'am.
All right, then I'm going to release you, Mr. Parker. Ms. Williams, if you'll just, you're ready, step in front of the clerk. She will give you the information now on who that attorney is and when you need to contact them.
Thank you.
Yes, ma'am.
Thank you, Judge.
Thank you. You're Cedric Martin Harris.
Yes, ma'am.
Back up, please. What kind of pants are you wearing?
PJs. I was rushing. Like,
Here's the thing. You've had an excuse every single time you've come to court.
if
If you come to court in pajamas or with house shoes or any of the other nonsense that you've been wearing,
Yes.
then there will be a warrant issued. I'm going to raise your bond and you're going to go to jail. If you want to go sleep in PJs, you can do it in jail. Don't show up like that again. Do you understand?
Yes.
There's nothing about this that's funny. There's nothing about, you shouldn't be rushing. Wake up early, get here on time. We've had this problem every single time. So why were you late today?
I was like today to my mama, well, I woke up on time this morning and I was to wake my mom up, but she didn't wake up because I guess she was on her medicine. I guess it still made her tired, but I hurried up and woke up this morning and stuff like that. And yeah, that's it, Judge. I'm sorry. And
Did you go talk to some lawyers?
Yes, ma'am, I did.
Who'd you
But-
talk to?
I talked to Mr. West. He still hasn't given my price yet.
Who?
Mr. West.
Okay.
He haven't given my price yet. I haven't come back contact with me. And I talked to Mr. Rife. He charged me 1,500. And I talked to Jade of Peros of Law Enforcement in Beaumont, Texas. She told me if I was to plead guilty, my charge would have been 5,000. And if I was to plead, no, my bad, I'm sorry. If I was to plead guilty, my total would have been 35,000. Oh, not, and if I was to plead not guilty, my charge would have been 5,000. And I also
3,500, not 35,000, I'm guessing.
I'm sorry. And I also contact the criminal authority, Mr. Dustin. He wasn't in his office.
Okay.
And I also called Miss Larnie Caroso.
Mm-hmm.
She didn't answer either, and they haven't came back into me. And
Did
the
you
drug-
get that drug patch put
Yes,
on?
ma'am, I did. I also got the drug patch overnight, and you did say like I only had it for a week overnight, and it's on me. I was taking a shower and stuff like that, and it was sleeping off, and I had to wrap it up. But today I'm finna go back up there to get a new one, so I don't get in trouble. But yes.
That's a definition.
Have you smoked since last week?
Nope. No, ma'am.
I want that drug patch on this week.
Yes, ma'am.
People wear drug patches all the time
Yes.
and they don't come off when they take showers.
Yes.
Okay. So whatever you have to do to keep that drug patch on, you do it.
Yes, ma'am. Like today.
I don't care. Doesn't matter. All right. The excuses don't matter anymore
Yes.
to me. If you're going to be out on bond, then you're going to wear the drug patch.
Yes, ma'am.
You have to wear it. You have to keep it on. If it means wrapping it up with something more than what they put on, I don't care how you do it. Make sure it's on. Make sure it's tested every 2 weeks. If it's not, and there's another issue with that drug patch, I will raise the bond. Do you understand?
Yes, ma'am.
There won't be any excuses of whatever you were doing.
Yes.
I'm going to have you fill out some paperwork today to see if you qualify for a court-appointed lawyer. Okay, thank you for doing most of what I asked you to do. You need to fill out this paperwork accurately and completely because you're going to swear under oath that it's true and correct, and then I'll take a look at it. I'm also going to recall that bond forfeiture. Step in front of the clerk on the end, bring your papers. And she'll tell you what you need to do with that paper. Good morning. Are you Dale McDonald?
Yes, ma'am. Good morning.
And will your client move the formal reading of the indictment?
Yes, Your Honor.
All right, Mr. McDonald, in cause number 26, DCCR 0113, you're charged with a first-degree felony offense of aggravated robbery, and that is from January 5th of 2026. And how do you plead to that charge?
Good.
Are you pleading guilty freely and voluntarily?
No.
And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yeah.
And do you understand? So there's no agreement.
Well, it's unagreed. We're asking for deferred and the state's waiting on the PSA.
Okay, so no agreement. So I want to make sure you understand, what you're doing is leaving your punishment up to me, which means I could sentence you anywhere in the whole range of punishment, from probation up to 99 years or life in prison. It's the broadest range there could be. What'll happen if we go forward this way is I'll reset the case. We'll get the probation department to do a pre-sentence report. We can have a hearing with any witnesses or testimony or evidence, whatever that anyone has to present. And then I would make my decision at that time based on all of that. You have an absolute right to have a jury come in and do 2 things. The first would be to find you guilty or not. And then if that jury finds you guilty, you can leave your punishment up to that jury. If we go forward this way, you're waiving that. And is that what you want to do? And so there will be a right to appeal. You guys signed the post-conviction waivers on the plea admonishment. Do you want me to mark through those? At the bottom of the second page, it's the post-conviction waivers.
Yes.
Okay. Mark that through. All right, state tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. McDonald's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, but I'm going to reset your case for sentencing Morning. Morning. Good morning, ma'am. Are you Murphy Lopez? Speak up.
Yes,
This is cause number 24, DCCR 0886. Ms. Lopez was previously in court, entered a plea of guilty to the state jail felony offense of driving with while intoxicated with a child passenger. There was no agreement in this case. I've received the pre-sentence report. Have you both had an opportunity to review that report?
Have you?
yes, Your Honor.
Any additions or corrections?
Not aware of Judge.
Not from the state.
So I want to start, I guess, with Ms. French on this one. This is a very typical kind of case where probation is typically the outcome. And so I guess I'm curious. Obviously, I understand and I saw the facts, and that gives me some concern. But I think there's some treatment and things like that that could be. I guess tell me, what's your position?
I would like to see Ms. Lopez get some kind of treatment. My primary concerns based on the evidence that was presented in my file and also with the PSI was that the substance that was being abused and the fact that Narcan had to be administered. That was very disturbing from the state's point of view. And if there are, we know there are programs regarding substance abuse, maybe issues with parenting, decision-making, definitely decision-making skills. There may be some kind of mental health issues or situations that she needs help with along those lines. The state is going to defer to the court on this one, but certainly we would hope to never see Ms. Lopez here again.
Ms. Lopez, I don't disagree with what Ms. French is saying. This was a very scary situation and could have turned into something really, really horrible with your children. And so, what I'm going to do today, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, find you guilty of driving while intoxicated with a child passenger. I'm going to sentence you to a term of 2 years in the state jail prison, but I'm going to probate that. You'll be on probation for 5 years. I'm ordering you to pay a $1,000 fine and to follow all of the rules and conditions of probation. Those are several things that are kind of typical. Also, there's going to be some that are especially for this offense. One is that you will enter and successfully complete the JCDI program. That is an intensive outpatient drug rehab program. You'll be required to follow all of the rules of that program. You're also going to be required to participate in any mental health services through Spindletop. So we're not trying to set you up to fail. What I want you to have is all of the tools necessary to be able to be successful. So if you're going to do a substance abuse assessment as well, if there's any other specific treatment that probation or that assessor thinks is necessary, then you're going to be required to do whatever it is that they ordered or that they recommend. Do you understand?
Yes, ma'am.
If you do everything you're supposed to while you're on this probation, then for all practical purposes, your case here in court is over. You will be able to serve your sentence out on probation. The other side of that, though, is if you violate any condition of probation at all, you will be back in court and you could be facing the 2-year sentence that I've already given you. Do you understand?
Yes.
Can I make a request, please?
Sure.
I mean, Miss Lopez is, I couldn't ask for her to be more cooperative with me and taking care of a case and taking this serious. She just, I mean, I'm sure the court has seen it in the PSI, but this is a wake up call to her, what she's told me. She doesn't have a significant history at all that I know of. She, after this incident, she has been required to wear a drug patch. And I get reports all the time that they're negative throughout her whole time on bond. Additionally, last week she called me freaking out because she took her kids to a water park and the patch came off. She said, what do I do? I said, call whoever installed it and tell them. And she said, I've already done that. I said, well, you ought to be fine then. So she went and got it replaced. She has got her associate's degree. She's got a job. She's trying to better herself even further, trying to become a physical therapist. And she's already taken a parenting class. I'm just wishing she could get deferred because I'm worried about the conviction.
I don't think
That's right. You're right. You're right, Judge. You're correct. You can't.
Yeah, I wouldn't disagree with any of that.
I wouldn't think of that. You're right.
Yeah, unfortunately, that is, I mean, there is a new on the misdemeanors where they can on some, but I don't think I can.
You're right. We had this before.
Okay. All right. So, I'm going to hand you the trial court certification. It shows this was not an agreement. There's some rights to appeal. You can talk to Mr. Parker about that. If you'll just have a seat here in the courtroom. What? Yes, ma'am.
Firearm admonition. This is an adjudicated.
Oh, thank you. Also, I'm going to hand you a written admonition regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. So if you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right. So just have a seat in the courtroom. Probation is going to call you to her desk when she's ready to go over your paperwork. So just watch for her to call your name. Good luck to you, ma'am. Thank you, Mr. Parker. Thank you, Ms. French. Good morning, sir. Are you Austin Tebow? And this is cause number 26, DCCR 1102. Mr. Tebow is charged with publishing or threatening to publish intimate visual material. And what is the announcement?
Yes, Judge, I believe this is Mr. Gallagher's first setting. We're just asking for a reset to work the discovery.
All right, any issues? I'll just do a normal reset, Mr. Tebow. That's about 30 days or so. Make sure you get in touch with and visit with your attorneys before the next court date so you can go over all of the discovery that they've received, and we'll see if we can get an announcement. All right, you're free to go. Thank you. Good morning. Are you Matthew Pham?
Yes, sir.
And this is 18-29698. Mr. Pham has a motion to adjudicate on a probation filed. Underlying offense is theft of cargo. And what is the announcement?
Your Honor, I'd like a little bit of time, please, to figure out what's going on with these misdemeanor allegations. Those are also old, and those may resolve, which could help us resolve this. We're also potentially able to make a pretty significant payment towards the restitution. I've informed the state of that this morning, and I'd like to see if we had a little bit more time. Also aware of how old this.
So this motion was filed back in 2022, and we haven't had any contact with Mr. Pham since then. Is that correct? Mr. Smith, any issue with it? So it was pled to a third degree.
It's still a third degree. I believe it, but the amount was more than that, but maybe restitution was paid up front or something. I'm not exactly.
Restitution was ordered in the amount of $99,999, and it was pled, I guess, from a second to a third for a 10-year deferred back in 2019. And the motion was filed in 2022. I'm going to reset it one time. Mr. Pham, you need to stay in touch with Mr. Kelly because I'm not going to put it on longer than about 30 days or so. All right. Okay. We'll see you back in 30 days.
Thank you, Judge.
Thank you. Good morning. Are you Austin Jones?
Yep, ma'am.
And Mr. Jones, this is your initial appearance in cause number 26 DCCR 1137. You are charged with a third degree felony offense of evading arrest or detention with the use of a vehicle from March 26th of 2026. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No.
So what I'm going to do, Mr. Jones, is reset your case for about 30 days to give you some time to try to hire someone.
I'll have to do that.
Well, if you bond it out, then I expect you to at least try to hire someone. So I'm going to give you 30 days to try to do that. And if you get someone hired before the next court date, just bring the reset notice that you get today to that lawyer, and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They all have different payment plans. Bring me back the names of the lawyers that you've talked to, so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would have to go back to jail.
Yes.
Do you understand?
Yes.
You'll step in front of the clerk. She'll give you a reset notice. Good morning. You're Lance White?
Yes, ma'am.
And Mr. White, did you get a lawyer hired?
Spoke with Mrs. Brittany Holmes. She told me about just to get some paperwork from you or something for her to be my lawyer. And I spoke with Mr. Durham out in Houston, Texas, and Rowan.
Okay.
I spoke with Miss Brittany Holmes. She wouldn't even. She just told me, "You've been to court?" I said, "Yes, ma'am." She said, "If they give you a piece of paper, the paper I had."
So your reset notice. So here's the thing, like we said, Ms. Holmes was appointed to represent you when you were in custody. So technically she's your attorney, but you can either hire her or hire someone else. It's so where are you on being able to get one of those attorneys hired?
Durham charged me, told me the consultation for my case would be, they would charge me for to be my lawyer. And I wouldn't be able to come up with that amount.
Sure. Who else did you talk to?
Ron Harris.
Okay.
And he's a little higher than Durham.
Okay. Did you talk to anyone else?
Besides that, 3, Brittany Holmes, Ron, and others.
And did Ms. Holmes, did you talk to her about hiring her?
I didn't even get that far with her. She just told me to get some paperwork from you guys and bring it to her office. I don't know what type of paperwork.
Well, that's if you have a court appointed attorney. Are you working?
Yes, ma'am.
Okay. Where are you working?
I work at Basin Hotel in Port Arthur.
So it just depends, Mr. White, on your income and your bills. I'm going to have you fill out some paperwork this morning to see if you qualify for a court appointed lawyer. You need to fill it out accurately and completely because you're going to swear under oath that it's all true and correct, and then I'll take a look at it. If you step in front of the clerk on the end, she'll give you that paperwork. And sir, you're Tevin Edmondson?
Yes, ma'am.
And Mr. Edmondson, were you able to get someone hired?
I was originally gonna go with Miss Brittany Holmes, but I had this accident, so my funds kind of got messed up. So I spoke with Mr. Marvin Lewis, and he's willing to work with me. So this evening I will meet him. If you can give me like a week or 2 week reset, and I have more information for you.
Okay, so you think you're gonna be able to get Mr. Lewis hired?
For sure.
Okay, well, I'll give you just a normal reset. That'll give you 30 days,
Yeah.
right? So if you get Mr. Lewis hired, just bring the reset notice that you get today to him. He'll tell you what to do. If for some reason that's not going to work out, talk to some other attorneys, see if there's someone else. If there's still an issue because of your accident, just bring me some documentation of that and then we'll talk about your options, okay?
I apologize again for this.
It's okay. I totally understand. Thank you, sir, for the apology. Step in front of the clerk. Good morning. Are you Marin? Is it Ezel? Ezel? And Mr. Ezel, this is your initial appearance in cause number 26 DCCR 1062. You're charged with theft of property with previous convictions from April 8th of 2026. Your indictment alleges several prior offenses of, well, it's like a few of theft and then there's some possessions back in 2009. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No, ma'am.
Let me look at something real quick. So what I'm going to do is reset your case for about 30 days to give you some time to try to hire someone. If you get someone hired before the next court date, then I'm ordering you, or then just bring the reset notice that you get today to that lawyer if you hire someone. If you're unable to hire someone, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me the names of the lawyers that you talk to, so I know you're trying, and we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would go back to jail. You understand? Step in front of the clerk. She'll give you a reset notice. Good morning, sir. You're Levester Hassan. And Mr. Hassan, did you get someone hired?
Hired.
Who'd you talk to?
And person. That's what I'm trying to get.
Who?
We got. I remember his name. We're the one I was trying to get from last time.
So if you're unable to get him hired, I'm pretty sure I told you to at least talk to some others to see where are you on the getting somebody hired.
That's it.
Well, who else have you talked to? How do you know they're all employed?
The prices that they ask them for. There's a lot of them.
Who all have you talked to?
Everything happened to
Why wouldn't you write that down and bring it to me like I asked you before?
me experts. I was writing them down and bringing them. I'm trying to go with that one.
With Mr. Macon? If you don't even remember his name, how are you trying to go with him?
I know it when I see it, like the court appointed, not option, you know.
Well, it just depends. You got to do what I asked you to do first. If I test you this morning, you gonna have anything in your system?
No, I'm sleep.
You're sleepy? Have a seat in the jury box. Let's get you tested, make sure. Good morning, ma'am. Are you Christy Johnson?
Yes.
Ms. Johnson, did you get someone hired?
No, because every time I call Mr. Marvin Lewis, there's no one ever available. I think I need a better representation anyway. So if you ask you for a little bit more time, I do want to pay for my own lawyer.
Okay, but you've been coming here for months now. So you had 30 days since that last court date to do that. Why haven't you talked to anyone else since then?
Because I thought Mr. Marvin was gonna answer his phone, and I did speak with Donna Boudreaux, and I also had y'all get on to the fucking with Samuel. So it's just, I don't know, it's hard for me to get in contact with somebody.
All right, so here's what I'm gonna, you have the money to hire someone though, you think?
Working, so I get paid every week, plus I get tips.
So I'm gonna reset your case one more time. All
Okay,
right, you
please.
need to get someone hired before that next court date.
Yes, ma'am.
If not, I want you to bring me pay stub, how much you make, and tell me you need to have written down. I want you to talk to at least 3 other attorneys.
Yes, ma'am.
Okay? All
Thank
right,
you.
step in front of the clerk. Good morning, sir. Come on.
Oh, sorry.
Are you Glenn Willis? Mr. Willis, this is your initial appearance in cause numbers 26 DCCR 0989 and 26 DCCR 0990. In each of those cases, you're charged with aggravated assault with a deadly weapon from December 2nd of 2025. And since you've made bond in your case, both of those cases, have you had an opportunity to try to hire a lawyer?
Yes, ma'am. It's Dustin Galmore. Miss Haley's supposed to represent you here at 9 o'clock.
Good morning. Miss Simmons is here
That's it.
on Glenn Willis.
I believe he retained just late last night, Your Honor. We'll probably be filing a letter of rep today.
Okay. So you've actually paid, Mr. Galmore and took care of all that. Okay, so what I'm gonna do is just reset it to another designation, but once they get that filed, just, they'll let you know when your next court date is, but I'm gonna have you file sign a reset today. You can give that to Ms. Simmons. They'll let you know when you need to be back, if it's not on that day, okay? Step in front of the clerk. Thank you, Ms. Simmons. And Ms. May, this is cause number 23, DCCR 2188. You have a motion to revoke your unadjudicated probation. Look at something. So Mr. Rojas asked that I set up on, I did. Do you have that drug patch on?
Yes, ma'am.
Have you been getting it changed every time you're supposed to?
Yes, ma'am.
Okay, you don't have any notices of anything that I don't see? So since you've made bond in your case, have you had an opportunity to try to hire a lawyer? So what I'm going to do, since you made bond, Miss May, is expect you to try to hire your own lawyer. So I'm going to reset your case for about 30 days to give you some time to try to get someone hired.
Okay.
If you get someone hired before the next court date, then you need to bring the reset notice that you get today to that lawyer, whoever it is, and they'll tell you what to do.
Okay.
If you're unable to hire someone before that next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to, so I know you're trying, and then we'll discuss your options.
Okay.
If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would go back to jail. Do you understand? Give me just a second and look at something.
So Mr. Ray Hobbs will no longer be represented.
So Mr. Rojas is your attorney at this time, but because you made bond, I expect you to try to hire someone. If for some reason you go through that process and you're unable to afford someone, then we'll discuss your options on having a court appointed. But because you made bond, I expect you to at least try.
Okay.
Okay? All right, step in front of the clerk. She'll give you a reset notice.
I can continue wearing these?
Yes, ma'am. Good morning, ma'am. You're Miracle Oville.
Yes, ma'am.
And Ms. Oville, did you get someone hired?
No, I did not. Since the last time I came a month ago,
Since what? I'm sorry?
when I last came to my court date or whatever, like my job had already been fired, but because I came back with another court date, I was fired.
Where were you working?
At an industrial company. It was called Mike Howard,
Have you talked to some lawyers?
No, not besides the one that I intended on hiring since the last time that I told you about.
Who was that?
I honestly don't remember his name. I can't remember.
So if you were thinking about hiring someone, how do you not know who it was?
Well, I wrote it down the last. I have the messages in my the phone, but my phone broke. I just recently got a new phone.
Have you been looking for a new job?
Yeah, I have. I work with the same staffing company that I got the job with, TPI Staffing.
I need you to speak up and speak slower.
I work with the same staffing company that got me hired.
Okay.
TPI Staffing and another staffing company called Carter Staffing, and I also work with the Workforce Solutions out there.
Okay, so I'm gonna have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer, okay? You need to fill it accurately and completely because you're gonna swear under oath that it's all true and correct, and then I'll take a look at it. You need to step in front of the clerk on the end. She'll give you that paperwork. Good morning, sir. You're Brian Belvin?
Yes.
And this is cause number 25 DCCR 1485. Mr. Belvin, it looks like was accepted in a pretrial diversion, and we're just checking in. Mr. Nichols?
Judge, my notes from Ms. Molfino indicate that he is participating and being successful so far in JCDI,
Okay.
and that they expect that to continue, and that'll end up taking care of this case once he does complete the program.
How much longer?
She was asking for a 3-month reset, 90 days.
90 days?
Yes,
Okay.
sir.
We'll do 90 days.
It's a year program that I've been there 3 months, so 9 months.
He has 9 months left.
Okay, we'll do 90 days. And at that time, if you'll get with Ms. Malfino the week before, and if everything's going well, we could probably do a
Okay.
reset without everybody having to come down.
Appreciate
for
it.
it. Just let me know, but make sure that week before, talk to
Okay.
Ms. Malfino, she can check on it, and y'all just send me a
Okay.
message.
Okay.
All right.
Thank you,
Very
Your
good, sir.
Thank you for
Morning, ma'am. Are you Jasmine Jaquette?
Yes, ma'am.
And this is cause number, spit your gum out in that trash can over there.
Here, all right.
This is 26 DCCR 0240. Ms. Jaquette is charged with deadly conduct, discharging a firearm. Mr. Parker?
Your Honor, we're asking for reset. I've talked to Ms. Malfino about this, and I think there's a co-defendant
Judge, I have the co-defendants in this case, and it's gonna end up, I'm gonna have this one reassigned to me. And so I would ask for a reset also, just so Mr. Parker can get with her about what her options are.
Okay, sounds good. So, Ms. Jaquette, I'm going to reset your case about 30 days or so. Stay in touch with Mr. Parker so that once he gets with Mr. Nichols, he'll know what your options are, have all of the discovery, and you can, we'll get an announcement at the next court day.
She has actually called me.
All right, good. All right, good. We'll see you at the next court day. You're free to go. Good morning. Are you Calvin Smith?
Yes, ma'am.
And Mr. Smith was previously in court in cause numbers 25 DCCR 1638 and 1639, entered pleas of guilty to those offenses, and I've received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, Your Honor.
Yes, Judge.
Any additions or corrections?
Not from the state.
All right, Mr. Smith, I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily. Find sufficient evidence in each case to find you guilty. In cause number 25 DCCR 1638, defer all proceedings and place you on probation for 5 years. Order that you pay the $1,000 fine and follow all of the rules and conditions of probation. In cause number 25 DCCR 1639, also, defer all proceedings and place you on probation for 5 years. You're ordered to pay a $1,000 fine in that case also, and to follow all of the rules and conditions of probation. If you do everything that you're supposed to while you're on this probation, this is an excellent opportunity because you don't have a felony conviction on your record. And at the end of the probation, the cases will actually be dismissed and you'll never have the felony conviction. The other side of that is if you violate any condition of probation, then you can be brought back into court, found guilty of the offense, and sent to the state jail prison in one case for up to 2 years, and sent to prison in the other for between 2 years and up to 10 years. Do you understand? And I know there were some issues based on this offense and when you had your wreck, and I know your mom's helping you. You need to make sure and follow all of the rules. If you need help, if you're having trouble understanding and things like that because of the injury, then you just need to make sure, have her come with you, talk to probation so that you know everything you're supposed to be doing so you don't not do something you're supposed to. Does that make sense? All right, I'm handing you in each of your cases the trial court certifications. This shows that these were agreements that I followed, so you did waive your right to appeal. You need to have a seat in the courtroom. Probation's going to call you up to her desk when she's ready to go over your paperwork. So just listen for her to call your name, okay? Good luck to you, sir. Good morning. Are you Virginia Williams?
Yes, ma'am.
And let's see. Give me just a second to get this close. Judges 2-1 rejection.
Oh, I only did one. I did, Judge.
Yes. Is it the same
Yes,
to run concurrently?
yes.
The objection may fill in that in.
No, Judge. Sorry.
All right, so Ms. Williams, in cause number 26 DCCR 0218, you're charged with a state felony offense of theft of property with previous convictions. That's from November 25th of 2025. Your indictment alleges you were previously convicted of theft May 12th of 92, and then 3 cases, January 11th of 1994, again, October 9th of 2006, April 13th of 2011, May 2nd of 2012, October 6th of 2014. And then your indictment further alleges that you were convicted of forgery, a 3rd-degree felony, August 4th of 1995, 2 cases on that day of forgery, and then another of securing execution of a document by deception. And then after those were final, you were convicted of possession of a controlled substance, a 3rd-degree felony, December 18th of 2017. Well, what that means is that if you go to trial and you're found guilty and all of those prior, or at least some of those prior convictions are true, you would be facing punishment as a 2nd-degree felony, which is between 2 years and up to 20 years. Do you understand?
Yes.
And I have here, and that's in both of your cases. The second case is 25 DCCR 1430. It charges theft of property with previous convictions, and that one's from August 9th of 2025. Again, with those same prior convictions listed and the same possible punishment range. You understand that as well?
Yes, ma'am.
And then I have a plea bargain rejection that you've signed with Mr. Parker that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty to proceed on count one only for an 18-month state jail term in each of those cases that would run concurrently, which means together at the same time. You have every right to reject that offer and have your cases set for trial. I want to make sure you understand that before we go to trial, what your options are and what the possible consequences are if you go to trial. And do you understand all of that? And you want to reject that offer and have your case set for trial. Have both cases set for trial. Okay. I do want to also make sure you understand that after today, I will not accept this plea agreement. This plea agreement is already extremely low for the criminal history. Even though some of it's very old, it is significant. And so and it's fine, if you're not guilty of both of these offenses, then that's what a jury's for. So I'm not trying to talk you anything. I'm just trying to tell you that I'm not going to accept this plea agreement after today. Do you understand? Okay.
Just for the court to where it is that one reason it's been reset is there's supposedly people are going to sign a non-prosecution affidavit. Well, affidavits that she's not the one that did it, and she has got it signed, but it's not notarized. And I told they need to go to the DA's office. So that's the only.
And
thing
y'all
I
haven't
see.
had anybody come to
No.
do that?
No, Judge. So this is not my case.
I cannot hear you.
This is not my case. It's for the small females.
Okay.
But she has not. No, nobody has been there. Yeah.
Give me a
On the way up, he understands what's going on. Judge, I have my assistant going to help to translate. We're going to reject the offer today.
Okay, you need to do that in writing. There's a plea bargain rejection on the tablet, and then I'll call it up, and by the time she can be up here and help me go through that and make sure he understands all of that.
Yes,
Okay,
Your Honor.
I'll hold it.
Go ahead and do it.
All right,
I'm
thank
sorry, we had a little emergency in the parking lot with a different county and a Zoom.
Okay,
deals that-
that's okay, no problem.
He's on
Yeah,
it.
no problem.
We'll get it done, Judge. Thank
Sure,
you.
and if you need some help, I'm sure one of the attorneys can.
I probably will.
Okay.